Most Gen Xers think a will protects their family when they die. It doesn't. In fact, if a will is the only estate planning document you have, your family could spend months, maybe years in probate court, watching legal fees eat away at everything you worked for. By the end of this video, you'll know the 5 essential documents that actually protect your family and your assets. And if you're part of Gen X, the generation about to inherit $2.4 trillion in real estate over the next decade, you need to get this right. I'm not an estate planning attorney or certified financial advisor. I'm sharing what I've learned through my own estate planning journey and research. But here's what I can tell you. The mistakes I'm about to show you are costing families tens of thousands of dollars every single year. Let's make sure your family isn't one of them. Section 1. Why a will isn't enough. Here's the uncomfortable truth about wills that most people don't realize until it's too late. A will is a public document. When you die, your will goes through probate court, which means anyone can see exactly what you owned, who you left it to, and how much it was worth. Your nosy neighbor, your estranged relatives, complete strangers. Probate also takes time. The average probate process takes 6 to 18 months. During that time, your assets are frozen. Your family can't access them. They can't sell the house. They can't touch the bank accounts. They're stuck waiting while legal fees pile up. And those legal fees? They typically run between 3 and 7% of your total estate value. If you have a $500,000 estate, that's $15,000 to $35,000 going to attorneys and court costs instead of to your family. But here's what makes this especially painful for Gen X. You're the sandwich generation. You're caring for aging parents while still supporting your own kids. Many of you have blended families from second marriages. You have stepchildren, ex-spouses, complicated family dynamics. A simple will doesn't handle any of that complexity well. It creates confusion, it creates conflict, and it creates opportunities for family members to challenge your wishes in court. So if a will isn't enough, what do you actually need? 5 documents. Let me walk you through each one. Section 2. Document number 1. Living trust. The first document you need is a living trust. And this is the one that replaces probate entirely. Here's how it works. When you create a living trust, you transfer ownership of your assets, your house, your bank accounts, your investments into the trust. You're still the trustee, which means you still control everything while you're alive. Nothing changes in your day-to-day life. But when you die, the trust owns those assets, not you personally. That means they don't go through probate. Your successor trustee, the person you've chosen, can immediately distribute everything according to your instructions. No court, no delays, no public records. For Gen X, this is especially important if you own real estate. Remember that $2.4 trillion wealth transfer I mentioned? A lot of that is property. If you inherit a house from your parents and then pass it to your kids without a trust, it goes through probate twice. That's double the legal fees, double the delays, double the headaches. A living trust also handles blended family situations much better than a will. You can specify exactly how assets get divided between biological children and stepchildren. You can create provisions for a surviving spouse while still protecting your kids' inheritance. You can prevent your ex-spouse from having any claim on assets you want to go to your children. The cost to set up a living trust typically runs between $1,500 and $3,000 depending on your state and the complexity of your assets. Yes, that's more expensive than a simple will. But compare that to the $15,000 to $35,000 your family will spend on probate if you don't have one. Living trust. Essential document number 1. Quick question for you. Have you started your estate planning yet, or are you still putting it off? Drop a comment below and let me know where you are in the process. I read every single comment and I'll try to answer your specific questions. And if you're finding this helpful, make sure you're subscribed because every Thursday I break down complex financial and legacy planning topics into simple, actionable steps. Alright, document number 2. Section 3. Document number 2. Financial power of attorney. A financial power of attorney is the document that protects you while you're still alive but unable to manage your own affairs. Here's the scenario most people don't think about. You're 55 years old. You have a stroke. You survive, but you're in the hospital for 3 months recovering. During that time, who pays your mortgage? Who manages your business? Who has access to your bank accounts to keep your life running? Without a financial power of attorney, the answer is nobody. Your spouse can't access your accounts. Your adult children can't pay your bills. Your business partner can't make decisions. Everything freezes until someone goes to court to get conservatorship, which takes months and costs thousands of dollars. A financial power of attorney solves this. You designate someone you trust, usually a spouse or adult child, to manage your financial affairs if you become incapacitated. They can pay bills, manage investments, run your business, handle insurance claims, whatever needs to be done. For Gen X, this is critical because you're at the age where health events start happening. Heart attacks, strokes, serious accidents. You're also likely still working, still earning income, still managing complex financial lives. You can't afford to have everything freeze for months while courts sort out who can act on your behalf. One important note: make sure your power of attorney is durable, which means it remains in effect even if you become incapacitated. Some powers of attorney terminate when you lose capacity, which defeats the entire purpose. Also make sure it covers digital assets. In 2026, a lot of your financial life is online: cryptocurrency, online banking, investment apps, cloud-stored documents. Your power of attorney needs explicit language giving your agent access to digital accounts, or they'll be locked out. Financial power of attorney. Essential document number 2. Section 4. Document number 3, Healthcare Directive. Document number 3 is your healthcare directive, also called a living will. This is the document that tells doctors what medical treatments you want or don't want if you can't speak for yourself. Do you want to be kept on life support if you're in a vegetative state? Do you want aggressive treatment for terminal illness, or do you prefer comfort care? Do you want to be resuscitated if your heart stops? Do you want a feeding tube if you can't eat on your own? These are horrible questions to think about, but they're even more horrible for your family to answer if you haven't given them guidance. Without a healthcare directive, your family members have to guess what you would want, and they often disagree with each other, which creates conflict at the worst possible time. I watched this happen to a friend's family. His father had a massive stroke. He was on life support with no brain activity. The father had never discussed his wishes. Half the family wanted to remove life support. The other half wanted to keep him alive indefinitely. It tore the family apart, and it lasted for months. A healthcare directive prevents that. You make the decisions now while you're healthy and clear-headed. You write down exactly what you want, and then your family doesn't have to guess or argue. They just follow your instructions. For Gen X, this is especially important because you're watching your parents go through these situations right now. You're seeing firsthand how difficult end-of-life decisions are when there's no guidance. Don't put your own children through that same experience. Healthcare Directive. Essential Document Number 3. Section 5. Document Number 4, Healthcare Power of Attorney. Document Number 4 is your healthcare power of attorney, which is different from your healthcare directive. Your healthcare directive tells doctors what you want. Your healthcare power of attorney designates who makes medical decisions for you if you can't make them yourself. Here's why you need both. Your healthcare directive can't cover every possible medical scenario. Medicine is too complex. New situations arise that you couldn't have anticipated. When that happens, someone needs authority to make decisions on your behalf. Your healthcare power of attorney gives one person, usually a spouse or adult child, legal authority to make those decisions. They can consent to surgery. They can choose between treatment options. They can decide whether to continue or discontinue care. Choose this person carefully. It should be someone who knows your values, who will respect your wishes, and who can make difficult decisions under pressure. It should also be someone who lives close enough to get to the hospital quickly if needed. And here's something most people don't do but should: name a backup. If your first choice is unavailable or unable to serve, you need a second person ready to step in. Don't leave it to chance. For Gen X, this is particularly important if you have blended families. Make sure your biological children and stepchildren understand who has healthcare decision-making authority and why. Clear communication now prevents confusion and conflict later. Healthcare Power of Attorney. Essential Document Number 4. If you're still watching, you're clearly serious about getting your estate planning right. That puts you ahead of about 70% of Americans who have no estate plan at all. Before we get to the fifth and final document, hit that like button if you're finding this valuable. It helps other people discover this information, and honestly, more people need to see it. Alright, document number 5. Section 6, document number 5. Will? Yes, you still need one. The fifth essential document is a will. Yes, you still need one, even with a living trust. I know that sounds contradictory after I spent the first 3 minutes explaining why a will isn't enough. But here's the thing. A living trust only covers assets you've transferred into it. If you die with assets outside the trust, maybe you forgot to transfer something, or you acquired something new right before you died, those assets still need to go through probate. That's where your will comes in. It acts as a safety net, a pour-over will that catches any assets you missed and transfers them into your trust. It's not your primary estate planning tool, but it's an important backup. Your will also does something your trust can't. It names guardians for minor children. If you have kids under 18 and both parents die, your will specifies who raises them. This is absolutely critical for Gen X parents who still have teenagers at home. Without a will naming guardians, a court decides who raises your children. And courts don't always choose who you would have chosen. Maybe they pick your mother-in-law who you don't get along with. Maybe they pick your brother who's completely irresponsible. Maybe they split up siblings and send them to different relatives. Don't let a court make that decision. Make it yourself, in your will. One more thing your will should do. Specify how you want your digital assets handled. Your social media accounts. Your email. Your photos and videos stored in the cloud. Your cryptocurrency. Your online businesses. In 2026, these digital assets have real value, both financial and sentimental. Make sure your will addresses them. Will. Essential document number 5. Section 7. Putting it all together. So let's recap. The 5 essential estate planning documents every Gen Xer needs. 1. Living trust. Avoids probate, maintains privacy, handles complex family situations. 2. Financial power of attorney. Protects you while you're alive but incapacitated. 3. Healthcare directive. Tells doctors what medical treatments you want. 4. Healthcare power of attorney. Designates who makes medical decisions for you. 5. Will. Safety net for assets outside your trust, names guardians for minor children. Now I know what you're thinking. This sounds expensive. This sounds complicated. This sounds like something you'll get around to eventually. But here's the reality. Eventually comes faster than you think. Gen X is the generation that watched your parents struggle with estate planning or fail to plan at all. You've seen the consequences, the probate nightmares, the family fights, the assets lost to legal fees. You have the opportunity to do better, to protect your family, to make things easier for your children instead of harder. And yes, setting up these 5 documents will cost money. Probably $2,000 to $4,000 depending on your state and your situation. But that's a one-time expense that saves your family tens of thousands of dollars in probate costs and months of stress. It's also not as complicated as it seems. You don't have to figure this out alone. Estate planning attorneys do this every single day. They have templates, they have systems. They can walk you through the entire process in a few meetings. The hard part isn't the paperwork. The hard part is making the decision to start. And if you've watched this far, you're already there. You're ready. So here's what I want you to do this week. Not next month, not someday. This week. First, make a list of your assets, your house, your bank accounts, your retirement accounts, your life insurance, your vehicles, everything you own. This is the foundation of your estate plan. Second, have a conversation with your spouse or your adult children about your wishes. Who do you want to manage your affairs if you can? Who do you want to make medical decisions? Who should raise your minor children? Get these conversations started. Third, find an estate planning attorney in your state. You can search online, ask for referrals from friends, or contact your state bar association for recommendations. Schedule a consultation. Most attorneys offer free initial consultations. Don't wait until you're sick. Don't wait until you're old. Don't wait until there's a crisis. Do it now, while you're healthy and clear-headed and able to make good decisions. Your family will thank you. Trust me on this. If you found this video helpful, make sure you're subscribed to Silver Compass. Every week I break down complex financial and legacy planning topics into simple, actionable steps. Next week, I'm covering the biggest tax mistakes Gen X makes with retirement accounts and how to avoid them. You definitely don't want to miss that one. Drop a comment below and let me know. Which of these 5 documents do you already have, and which ones do you still need to create? I'll see you in the comments, and I'll see you next Thursday.